So this afternoon, I'm joined by Caroline Harley from our Brisbane office. How you going, Caroline?
I'm great, Dylan. How are you?
Yeah, not too bad at all. Thanks, mate. Look, obviously today we've heard a bit about recently about some changes to testamentary trusts, obviously in the recent budget. So I just thought this would be a great opportunity for us to have a bit of a chat about that, and obviously see where things are at, obviously at the moment with the changing landscape. But just to start with, what is a testamentary trust and how are they created?
Sure. A testamentary trust's created in a person's will, so it only comes into effect after they pass away. The trustee then manages the assets on behalf of the beneficiaries rather than assets that are being distributed directly to the beneficiaries. In contrast, a family trust, a family discretionary trust, it's typically set up during a person's lifetime and is used to hold and manage assets while they're still alive. So the key difference is timing and purpose. Family trusts are often used for the ongoing wealth management during life, whereas testamentary trusts are established through the will to manage inheritance after death. Historically, both structures have offered tax flexibility, although this is one of the key areas that is now affected by the proposed budget reforms.
Yeah. So jumping on that, obviously before the budget announcements, what role did testamentary trusts typically play in estate planning?
Yeah, before the budget, TTs or testamentary trusts have been a long standing and widely used estate planning structure in Australia. They've typically served three main purposes and, in some cases, offered tax efficiencies. But predominantly, those three purposes are providing flexibility, how and when beneficiaries receive funds, the tax efficiencies when distributions are made to minors or lower income beneficiaries. And those were not offered in family trusts prior to these changes coming into effect. So the family trust is very different to the testamentary trust taxation environment. But they've also been used in blended families or situations where control over inheritance is really important.
Yeah, I certainly see that in family law as well, sort of with testamentary trusts being obviously a major asset protection, protecting generational wealth as well. But what are the proposed changes people are now concerned about? Because that has been the buzz, obviously, in most of the morning breakfast shows at the moment. People are talking about these proposed changes. And what remains really uncertain, obviously, because we haven't seen any of the actual legislation yet.
Well, that's the thing. At this stage, we are dealing with proposed changes rather than settled law. So there's still a significant amount of uncertainty. But at the moment, the proposal is that from 1 July 2028, discretionary trusts, which includes family trusts and many testamentary trusts, will become subject to a minimum 30% tax, and that's paid by the trustee, rather than traditionally paid by the beneficiaries based on their individual tax rate. One important area still being clarified is transitional arrangements for existing trusts. Currently, it appears that existing TTs or testamentary trusts are likely to have some exemptions, but only on existing assets held on the 12th of May 2026, so when the budget was announced, but not on future assets or growth. So, details of transitional arrangements will be key in understanding how the changes impact many pre existing trusts and whether they're TTs or family trusts. It'll be really interesting to see how the government's proposing to deal with them.
Yeah, it is one of those difficult things for lawyers at the moment because I know a lot of people are making inquiries about this at the moment. I'm going to ask you to crystal ball something here, which is really, really unfair of me. But if these changes do proceed, what is the likely effect for people considering a testamentary trust in their will?
Well, that's the thing. If they do proceed as announced, the main impact is going to be the tax outcomes associated with trusts rather than the use of trusts themselves. So, for some families, this could reduce the tax advantages that they've traditionally used with the different types of trusts. However, trusts are rarely only used for tax purposes. They continue to play an important role in asset protection, succession planning, control of family wealth, and protecting vulnerable beneficiaries. And for some higher income beneficiaries who are already paying marginal tax rates over the 30%, the impact may actually result in a better deal for them.
Well, that's quite interesting, isn't it? Because that's sort of not what we're hearing necessarily everywhere at the moment. It's more that testamentary trusts will just be useless in the future, and that sort of looks to the next sort of thing that I was thinking about. Does it actually change the role of a testamentary trust from a tax planning tool to more of a succession and asset protection tool? Really, is that what we'll see more of these in the future? Do you reckon?
To some extent, yes. It may shift the emphasis. It depends on how someone's estate plan is structured. So, historically, testamentary trusts or TTs have offered a combination of tax effectiveness and asset protection. If tax benefits are reduced, the asset protection and succession planning benefits become even more central. So rather than disappearing as a tool, they may become more purpose specific. So they still provide significant benefits in protecting inheritances from bankruptcy, relationship breakdown, creditor claims, and family disputes.
Yeah, of course. So if somebody comes to see you tomorrow, obviously to look at doing their estate planning, are you going to approach things differently, or sort of how are you going to look at things when it does come to things like trusts, companies, superannuation, property, and personal ownership?
Look, modern estate planning is really about coordinating multiple structures rather than relying on a single vehicle. That can include trusts, companies, superannuation, business property, uh, personal property, business entities, personally held assets. The key is understanding that not everything is controlled by a will, and different assets can be governed by different rules. So, effective estate planning increasingly requires a whole of wealth approach that integrates tax, succession, control, and asset protection considerations together.
Yeah, that's really interesting, isn't it? It's that sort of pragmatic, holistic advice and approaches to everything altogether. I think that's just so important these days. But the thing as well that sort of people have been looking at now is discretionary trusts versus fixed trusts, and really what these proposed changes will actually mean. Do you have any sort of comment on anything like that at the moment?
Yeah, again, just remembering each structure serves a very different purpose. And that's the important of having good communication with your estate planning professional. So, if you've got a family discretionary trust, it gives flexibility during a person's lifetime in how income and capital are distributed. If you've got a fixed trust, that's predetermined entitlements. So, there isn't much discretion in how benefits are allocated, and it also weakens the asset protection. Often SMSFs fall into that fixed sort of category too, although the taxation does differ from other fixed trusts. When we're looking at testamentary trusts, that sits in a different category again. It's created through a will and comes into effect after death, but it's generally for succession planning and protection of inherited wealth. The key takeaway for everyone is that each structure serves a different purpose, and the right choice depends on whether the focus is flexibility, certainty, or post death control and asset protection.
Yeah, oh, absolutely. That all makes, yeah, a whole lot of sense.
Yeah.
But I think probably people will have heard these proposed changes, and everybody's run out and thought, "Oh God, I've got to change everything now." What do you have any sort of practical tips for people who are feeling probably a bit of stress, a bit of worry because they thought they had set up a future sort of thing with the previous laws and legislation surrounding estate planning? Is there any practical steps you'd be giving to anybody at the moment when they're considering their estate planning?
Absolutely. Look, realistically, you've got to always be aware that estate planning is understanding what you already have in place and the role that it's intended to serve. From there, it's important to regularly review how proposed tax reforms, legal changes, and family circumstances may affect those structures over time. For example, in Queensland, trusts can now potentially continue for up to 125 years rather than the traditional 80-year perpetuity period. So, if the trust deed is properly drafted, they can take advantage of that 125-year change. So, it's not just about reviewing tax changes that have been announced. It's having estate planning in mind that it's more than just tax. It involves asset protection, succession control, family dynamics, ensuring wealth will be transferred in the way that the family intends. One of the biggest risks in estate planning is simply doing nothing or
Mm.
doing it
Yeah,
once
absolutely.
and
Yeah.
then never updating it. The key message is that estate planning should be reviewed regularly, not just when there's a major life event or legislative change. So, some of my clients like to have an annual date every year that they'll sit down with a glass of wine or sit by the pool, whatever it is that they want to do. And they think about the people who are named in their documents, whether or not it's still appropriate, whether those people are still around, whether they're still friends. This is the important part of doing a review that might not just be triggered based on legal changes.
Well, I think that's also really important advice as well for not just wills, but also powers of attorney and enduring guardianship documents as well, because it's one of those things that the thoughts you might have had 5 years ago are not necessarily the thoughts are having now when you're looking at your life at the moment. So it is one of those ever evolving documents, and one of those things that I know personally. Once you tick it off and you get it done, it's sort of a huge relief for you. So thank you so much for your time today, Caroline. I really appreciate it. I know this is a really interesting and ongoing and moving feast really at the moment with the new changes coming in. So thank you so much. I really, really appreciate your time.
Not a problem, Dylan. Watch this space.
Cheers.